Hello everyone, very warm welcome once again to StudyIQ IS English, your favorite channel here. My name is Praveen Mishra and we are going to proceed with our course, the crash course on our Indian polity, and we are going forward with the next topic today, that is fundamental rights versus DPSPs, that is the directive principles of state policies. Okay, so versus as in not the proper tussle, not the proper battle, the differences as well as its implications in our Indian society. Okay, in our political as well as social structures. So, starting with the differences first of all. Okay, so what are they? So, first thing, as you can see, DPSPs, they are positive as they require the state to complete a task. Okay, when we talk about the basic differences, right? So, here we have. So, DPSPs, what are they? They are considered what? Positive. Why positive? Because they make the state, to perform. Okay, they make the state what? To perform. Whereas fundamental rights, they are negative as they restrict the state. As they what? They restrict the autonomy of the state. So, this is a negative. But negative for what? Negative for state only. Whereas DPSPs, they do make the state to do a task. Right? That okay, make panchayats, make the provisions for education for weaker sections, scheduled castes, scheduled tribes, make provisions for the environment protection, make provisions for the monumental protection, make also go ahead with the protocols of the international peace and agreements, right? Create a social order, provide the right to livelihood, okay, and so on. So these are what? These are the flexibilities given to the state that do these tasks. Whereas while discussing fundamental rights, we also discuss that fundamental rights, they impose the restrictions on the state. That is, they do provide us, that is the citizens, that is the masses, the protection against the arbitrary action of the state. And in order to provide the protection against the arbitrary action, so fundamental rights, they do restrict the states from performing anything. Okay, so that is why fundamental rights, they are negative for the state, not for the citizens, for the state, okay, as they restrict them. Whereas DPSPs, they are positive for the state as it provides them some extra space to work, right? Second, fundamental rights, they are justiciable in nature. That is, they are legally enforceable, right? And DPSPs, they are not, right? So what we have discussed in the previous session, according to Article 37, right, what we have? Article 37, right? What is that? It states that the provisions in this part, that is part 4, that is DPSPs basically, okay, what are they? They are voluntary for the state. Means the state may or may not want to carry them, wants to continue them. Okay, so if the state is willing to continue, that's fine. Even if the state is not, then no worries. No legal action could be initiated against the state, right? So, voluntary in nature. But on the contrary, fundamental rights, what are they? They are mandatory in nature, right? So, what is written here? Fundamental rights are justiciable, that is, they are legally enforceable by the courts in case of their violation, whereas DPSPs are non-justiciable. And where is this mentioned? This is mentioned even in Article 37 of the Indian Constitution, Part 4, right? Third thing, what is the next one? It aims, that is the fundamental rights, they aims at establishing a political democracy in the country, whereas DPSPs, they aim at establishing the social and economic democracy in the country. Now, the difference with regard to their ideology. Okay, with regard to the ideology of the DPSPs as well as the fundamental rights. So, on the one side, we have got the fundamental rights. On the other, we have got the DPSPs. So, when we talk about fundamental rights, it provides us what? It provides us the political freedom. Okay, the political equality as well as the political freedom, right? But when we talk about DPSPs, they do provide what? They do provide social and economic freedom or the economic democracy. Okay, so this is the basic difference. So providing political democracy or providing political freedom or equality, it is what? The fundamental rights. But providing social along with economic freedom or the democracy, it is what? DPSPs, right? So another big difference. Next, fundamental rights, they promote the welfare of the individual. Hence, they are personal and individualistic. Whereas the DPSPs, they promote the welfare of the whole community. Hence, they are solitarian and socialist. Okay. So, fundamental rights focuses on the individual. Whereas DPSPs, they do focus on the society or the nation as a whole. Right. So, fundamental rights, individual, that is type of micro. Whereas DPSPs, type whole of the nation, that is type of macro. In economics, you might have encountered these terms, right? Microeconomic, macroeconomic. Microeconomic is what? Focusing on an individual. Macroeconomic is what? Focusing on the whole of the society or the whole of the nation. So here it is also. Fundamental rights, they are what? Focusing on the individual's growth and development. Whereas DPSPs, they are targeting towards the growth and development of the nation as a whole, the country or the society as a whole. Right? So the that is fundamental rights, they are individualistic. Whereas the other one, that is the DPSPs, they are more of the socialistics. Right? Last one. Fundamental rights do not require any legislation for their implementation. That is, they are automatically enforced. While DPSPs, they require legislation for their implementation. They are not automatically enforced. Okay. So last big difference, fundamental rights, they are automatically imposed. No need to do anything. Okay, no legislation is required for the imposition or the enforcement of the fundamental rights. But in case of DPSPs, a proper legislation is required. Okay, a proper enactment of the statute is required for the sake of their enforcement. Okay, so fundamental rights, basically speaking, simply speaking in layman term, it is automatically enforced. Okay, simply that's it. Whereas the DPSPs, they need a push. Okay, they need a force, that is basically called the enactment of a statute. Okay, so these are what? The basic differences among the factors, that is fundamental rights and DPSPs. Okay, so I hope it is clear. Moving to the next of the cases, which has provided us with some landmark judgments by the Honorable Supreme Court of India. The first one, what you can see on your screen, is Champakam Dorairajan case of 1952. Right? What was the court verdict? All fundamental rights are superior over DPSPs. Okay, Champakam Dorairajan, the very famous case with regard to the reservation policy in our country. Right? So though we are not going to discuss about the cases, all of the cases in detail today, we will be discussing the cases, but in the next session. Okay, for now today here, with regard to the conflict between fundamental rights and DPSPs, we are mentioning here or referring here with some of the cases. That is the first one, Champakam Dorairajan case of 1952. In this, the Supreme Court stated, all fundamental rights, they are superior over DPSPs. All of them. Fundamental rights, all of them, they are superior over DPSPs. Then comes the next era, the next case. Kerala Education Bill. The doctrine of harmonious construction came into being. The most important thing with regard to the conflict between fundamental rights and DPSP is what? The doctrine of harmonious construction. In the Kerala Education Bill case of 1957, the Supreme Court had propounded the doctrine of harmonious construction to avoid a conflict while enforcing DPSPs and fundamental rights. Okay, so in order to implement the DPSPs and fundamental rights, there could arise many of the conflicts, and in order to prevent that conflict, a shield has been created in the name of a doctrine. And what is the name of the doctrine? Doctrine of harmonious construction. Okay, so as per the doctrine, what are the features of the doctrine? As per the doctrine, the court held that there is no inherent conflict between the FRs and DPSPs, that is fundamental rights and DPSPs. And the courts, while interpreting a law, should attempt to give effect to both as far as possible. That is, should try to harmonize the two as far as possible. So basically, Supreme Court stated that there is no conflict between fundamental rights and DPSPs, but while enforcing them, it is the duty of all of the courts, that is the judiciary, to create a balance between the imposition of both, that is fundamental rights as well as DPSPs. Okay, one should not dominate the other. Okay, one should not infringe or abrogate the other. Right. Further, the court said that where two interpretations of a law is possible and one interpretation validates the law while other interpretation makes the law invalid or the unconstitutional and void, the first interpretation which validates the law should be adopted. But if only one interpretation is possible, which leads to the conflict between DPSPs and fundamental rights, the court has no option but to implement the fundamental rights in preferences to DPSPs. So what Supreme Court has stated? Let's say, for example, for one law, two different interpretations are available. First one, which validates the law. Okay, that is correct. But second interpretation, the second point of view, okay, the second angle, it says that no, the law is wrong. It is unconstitutional, should be null and void. So which POV, which point of view, which angle, which interpretation should I go ahead with? The correct one which validates the law or the incorrect one that provides the law as unconstitutional? So I should be always going ahead with the correct one. That is the interpretation or the angle or the point of view that validates the law. And the very next thing here, Supreme Court in the very same case of Kerala Education Bill has stated that in case there is a fundamental right that is being overridden by a DPSP, it should not happen. It should clearly not happen. This is what 1957 Supreme Court has stated. Okay, in case there is a conflict between fundamental rights and DPSPs. Let's say fundamental rights are overriding DPSP or DPSPs are overriding fundamental rights. So in any of the case, in either of the case, who should be winning? Whether it should be fundamental rights or whether it should be DPSPs. So it is absolutely crystal clear by the judiciary, it should be fundamental rights only. So in case, first of all, there exists no conflict, but in case, while implementing a DPSP, a fundamental right is infringed. While implementing the fundamental right, a DPSP is infringed. So in either of the two cases, who should win? The judgment is clear. The answer is clear. It should be only and only fundamental rights. They are given preference to DPSPs. Okay. Then we have got 1967, a decade later, in IC Golak Nath versus State of Punjab case. So here, the Supreme Court verdict, it was fundamental rights cannot be abridged or diluted. Okay. No one, in any case, in any circumstances, can abridge or dilute the fundamental rights, but for which Parliament gave a reaction. The Parliament responded again actually, by bringing the 25th Amendment Act of the Constitution and inserted Article 31 capital C, which says that some certain DPSPs, they can be used to override fundamental rights. And what are these DPSPs? Only two. Article 39 Clause B and Article 39 Clause C. One talks about the equal distribution of resources, and second one, that is Clause C, talks about there should be no concentration of wealth among the masses. So it was also stated when Article 31 capital C comes in, Article 14 goes out. Right? Okay. So if a law is made to give effect to DPSPs according to Article 31 capital C, okay, what Article 31 capital C has stated, if a law has been made to give effect to DPSPs under Article 39 Clause B and Article 39 Clause C, and in this process, while implementing Clause B and Clause C of Article 39, in this process, the law violates Article 14 or even 19 or 31, okay, then the law should not be declared as unconstitutional, okay, and void merely on this ground, right? So simply what has been stated, that in order to have the proper implementation of Article 39 Clause B and Article 39 Clause C, right? Article 31 capital C comes to the rescue, and it says that fundamental rights under Article 14, 19 and 31 can be compromised. Okay, how many? Article 14, 19 and 31 can be compromised in order to, when it comes to the proper implementation of DPSPs that are guaranteed under clause B and clause C of Article 39. That is, Article 39 clause B says that equal distribution of resources should be there, and Article 39 clause C should be 39 clause C states that there should be no concentration of wealth, literally no concentration of wealth among the masses, right? So in order to implement these two, that is 39 clause B and 39 clause B, if Article 14, 19 and 31 they are being infringed or violated or abrogated or something like that, then no worries, as Article 31 capital C according to the 25th Constitutional Amendment Act has been added there, and it provides legal protection, right? Okay, so this is what Golak Nath case 1967 and Parliament's response. Next comes the Kesavananda Bharati case. The above amendment, that is the 25th amendment, was challenged in the Kesavananda Bharati case of 1973. The court's verdict, what court has stated? The Parliament can amend any part of the Constitution, but the new addition was given to the family of doctrines. What is that? Could not destroy the basic structure of the Constitution. Right? The Parliament can by law make any further statute. Yeah, no problem. But Parliament will have to keep this thing that while amending or making any statute, making any new rule or regulation or law, it should not be violating the basic structure of the Indian Constitution. Basic structure is secularism, the socialist structure, the democratic state, okay, the federal structure, the quasi-federal structure, whatever we have. Okay, apart from that, the supremacy of fundamental rights, independence of judiciary, the interstate relations. Okay, these are what? Basic structure. So the Parliament will have to keep this thing in mind while they are legislating anything. Okay, yes, you go ahead and legislate anything, but keep this thing in mind that your any type of legislation is not disturbing the basic structure of the Indian Constitution. Right? So this is what the Supreme Court has stated, in which case? In the Kesavananda Bharati case of 1973. Further, to come to Article 31 capital C, Supreme Court has stated, okay, that is, the court held that the power of judicial review cannot be taken out by Parliament, as judicial review is also part of the basic structure. Okay, so judicial review is basic structure? Yes. Can Parliament take away the basic structure? No. That is, can Parliament take away the judicial review? No. Okay. So here, the Parliament's reaction. Parliament brought the 42nd Amendment Act in 1976, which extended the scope of the above provision, that is of Article 31 capital C, by including within its purview law to implement any of the DPSPs specified in Part 4 of the Constitution and not merely Article 39 clause B and C. So before 42nd Amendment, that is till 25th Amendment, Article 31 capital C was providing legal immunity to only two of the DPSPs, that is Article 39 clause B and Article 39 clause C. These are the two. But the 42nd Constitutional Amendment Act provided more coverage to Article 31 capital C, and it stated that now all of the DPSPs can be given priority when it comes to the fundamental rights, for which Supreme Court said no, never, okay, not possible. So next happens the Minerva Mills case of 1980, 7 years later, or simply speaking 4 years later of the amendment of 42nd. Okay. So a law under what Supreme Court has stated, a law under Article 31 capital C would be protected only if it is made to implement the directives under Article 39 clause B and C and not any of the other DPSPs. Okay, so the extension to all DPSPs was declared as unconstitutional and void by the Supreme Court in the Minerva Mills case of 1980. That's it. Okay, this is what Minerva Mills case 1980. Okay, and the statement, that is when Article 31 capital C comes in, Article 14 goes out. came from which case? So it came in the year 1982 through the Sanjeev Coke Manufacturing Company versus Bharat Cooking Coal Limited, 1982. Okay, so Sanjeev Coke versus Bharat Cooking Coal Limited, 1982. In this particular case, Supreme Court gave the very extraordinary statement. That is, in order to provide legal immunity to Article 31 capital C, that is basically Article 39 clause B and clause C, Article 14 can be compromised, and hence the statement comes in. When Article 31 capital C comes in, Article 14 goes out. What is the case name? The reference, Sanjeev Coke versus Bharat Cooking Coal Limited, 1982. Okay, guys, so that's it from my side today here in this session. And apart from that, please, if you haven't subscribed yet to our Study IQ English channel, so please do hit the subscribe button. And apart from that, stay updated with all the latest updates from our channel. And yes, if you wish to connect with me over through any social media handles, so here they are. So for Instagram, it is Praveen Mishra underscore 2107. And for Telegram, it will be study underscore with underscore Praveen. So wherever you guys wish to connect, that is over Telegram or Instagram, okay, you can connect. Let me know your doubts related to your academics, your UPSC CSE preparation. And yes, I'll try to connect with you at the earliest possible time. And yes, we'll for sure let your doubt go out. Okay, thank you so much, guys, for watching me in here, and please do hit the like button as well in case you like the video. Bye bye, see you all soon in the very next session. Good day, take care, study well.